by no means a substitute for any attorney's advice. It is just a broad overview of the foreclosure process, as well as steps that you would want to take if you were to receive a notice of default from your lender or servicer stating that you have missed a payment and you're in foreclosure. A couple things to go over. Once you receive a notice of default, I think the biggest thing you need to do is you need to prepare. You need to create a time frame in which you missed the payment and when you received your notice of default. One of the things that I tell clients to do is to, or what I do for our clients, is to request an accounting of your loan. Now, keeping a chronological file, it enables you to keep track of all your correspondence in a very organized way. You would want to start off doing one of these 6 things. You would want to go to, get on a computer, get on the internet, visit the recorder's website, get a printout of the record of your property. To do this, you would need your assessor's parcel number, and you'd be able to find that within your tax information, your property tax information. Then you would need to go to the assessor's website. It's going to show the name and entity that holds title to your home. Since mortgages get shuffled around a lot between servicers and even lenders, you're going to want to find out who your servicer is. Now, obtain a copy of your credit report. A foreclosure is going to negatively impact your credit score. Any late payments trigger the lender to report it to the credit reporting agencies. Another thing that you can do is you can send out a RESPA letter. Now, you can find a copy of that on various websites, government websites. You can just type in RESPA letter, get a template, and follow those procedures. RESPA stands for the Real Estate Settlement Procedures Act, and you can send a notice of error to your lender and ask for additional information, such as an accounting of your loan and asking for all the payments that you made and basically all the adjustments, basically a full accounting of your loan. Okay, so the mortgage system in Nevada. In Nevada, Nevada is a non-judicial foreclosure state. Technically, it's a quasi-judicial foreclosure state, but for the most part, I'll just be dealing with the non-judicial aspect of it. The first official act in a foreclosure is you receive a notice of default. Now, the statute requires the lender to inform the homeowner of the amount needed to cure the default. Now, the trustee must record the notice at the county recorder's office. A notice must be sent by registered or certified mail to the homeowner with a return receipt requested. And now typically the trustee of the deed of trust does this. I'm going to get into a little bit later in terms of the differences between a lender, a servicer, a deed of trust, trustees, things of that nature, a little bit later in this presentation. Okay, now who owns the note? Typically the company that you make your payments to does not own your loan. Sometimes you have an entity that acts as a servicing agent. Now, typically, entities such as Bank of America will do this, and there'll be a mortgage loan servicer for your loan. Now, this typically operates under a contract. It authorizes for that entity to act on behalf of the owner of the mortgage. Okay, so what is a note? Essentially, it is a document that says that you borrowed money and you owe a certain amount of money. Now, this will indicate the interest rate, the payment duration, the amount owed, whether or not there's an adjustable rate. It is an adjustable rate mortgage, as well as if you need to make any escrow payments, along with your payments on your note. Deed of trust. A deed of trust is a third-party security instrument conveying legal title to real property as security for the repayment of the loan. Now, to break this down, the owner is called the trustor. The third party to whom the bare legal title is conveyed is known as the trustee, and the lender is the beneficiary. So when the loan is paid off, the trustee is directed by the, yes?
May you repeat the 3?
There's
the trustor is the owner.
Yes, the owner is called the trustor.
And who's the next one?
The third party that has bare legal title is the trustee.
The trustee.
We'll wait a moment for
Okay.
the young lady in the back to have a seat. And the lender is the beneficiary. Now, once your loan is paid off, the trustee is directed by the beneficiary to issue the deed of reconveyance back to the trustor. And this will extinguish the deed of trust. Okay. So this document is the contract that you sign, which you give title to your house and security for the lender giving you the loan. Now, I'm going to go over a couple of concepts that you need to understand when you go through the mediation process or when you're speaking to your lender that many people don't fully understand, so I'm just going to give a brief explanation. So the term underwater. When you're underwater on your loan, it basically means that you owe more than your house is actually worth. A deficiency is when your home is sold for less than what is actually owed on the note. Now, I'm gonna go into a little bit more of a complicated explanation of what's gonna go on with if you receive a deficiency judgment. So Nevada is a deficiency state, meaning the lender has 6 months to pursue the homeowner for the deficiency. Now, I wouldn't get too excited because this only applies to loans originated after October 1st, 2009. So if your loan was originating before that time period, you're still liable for the deficiency. And later on, we'll get into how you're able to discharge that or go through foreclosure alternatives to help avoid the deficiency. So the parties involved with a foreclosure. You have the trustee of a deed of trust. This is not to be confused with the trustee for securitized pool of mortgages. That's a little bit more complicated scenario. I'm not going to get too much into that. So the trustee for the deed of trust is the owner of the note that typically forecloses based on the deed of trust. Now the trustee is the one who issues notices and arranges for foreclosures. The reason that this is important is because once you receive a notice of default, you're going to be receiving documents from the trustee or servicer. If you receive a document that you don't necessarily recognize the entity, please do not throw that piece of mail away. It could contain information that is pertinent and important to your foreclosure. Okay, so the servicer. The servicer is the entity that interacts with the homeowner. Now, they're also the ones that make sure that the insurance and the property tax is paid. Now, I'm only going to go over just a little bit of the trustee of a collateralized debt obligation, the trustee for securitized owner of the note. The common names that we see when we deal with these collateralized debt obligations are U.S. Bank and Deutsche Bank, and quite often loans can be sold and securitized and they end up as collateralized debt obligations. You have a wealth of information available to you here in the law library. If you have any questions or you need to look for other information, the law librarians will be happy to help you. Okay, so credit reporting. So when you fail to make a payment, there are obvious credit consequences for your late payments. Now, when you think of what occurs during the bankruptcy and how it'll most adversely affect your credit score, a bankruptcy is one that does the most damage to your score. So if you're considering a bankruptcy, you need to really make sure that this is the option that is best for your situation. Now, a short sale and deed in lieu does the least damage, and these are foreclosure alternatives that I'll get into later. If you have any questions about them, you can please feel free to raise your hand and I'll answer those questions. Now, if a foreclosure goes through the full process, that kind of falls in the middle of how it damages your credit score in between the deed in lieu of foreclosure, short sale, and a bankruptcy. Now, if you were to secure a loan modification for your home, it will be reported to the credit bureaus during the trial period plan until the loan mod is completed, the loan modification. Now, there are certain consequences if you receive a loan modification from your lender, okay? Now, if you receive a principal reduction or a loan forgiveness from the lender, say they take off a portion of the principal amount, adjust the interest rate, for that principal amount that they adjust, you're going to have to report that, and that may result in a tax liability. And the lender will often issue a 1099 form. Now, if this occurs, you're going to want to seek tax advice from an experienced tax agent. There are various options once you enter into foreclosure. I'll be talking about those options. If you have any questions, please raise your hand. So one of the options, you receive your notice of default. This is the first action within a foreclosure case. They'll send it to you with return receipt requested, and you'll receive it saying that you owe a specific amount of money. And you can pay this amount of money to reinstate your mortgage. So at that point, you're going to want to assess your options and what you want to do. One option is you can walk away, simply walk away. That's not going to be beneficial to your circumstances, and I highly advise against it. But it is an option. Another is you can file for bankruptcy. Now, say you decide to short sell your home and you have a deficiency on your home, and now you're worried about the bank coming after that amount because your loan was originated before October 1st, 2009. Now, there are various ways to get rid of it. One is a Chapter 7, which will entirely extinguish it. Now, if say for instance, you want to keep your home and you just really fell behind, things happen, medical emergencies, you have to pay for medical costs that you weren't expecting, but you really want to keep the home and you only feel like you're so far behind. And so another option is Chapter 13. Okay, and when you file a Chapter 13, I'm not going to get into all the details of what it's going to take, just the overall aspect. So if you're approved in the federal court for a Chapter 13 bankruptcy and they create a payment plan for you, now that payment plan is typically going to range between 1 to 3 years, and you're going to be paying back any arrears or any amounts for the reinstatement for your loan. Now that's going to be, they're going to look at your income and they're going to determine what your monthly payment is going to be. At the end of that payment period plan, when you file for Chapter 13, your loan is going to be reinstated to its original terms. So you'll be going back to the way you were making payments before with the same terms in your loan. That's an option, say for instance, if you're, often it comes about when you have 2 mortgages on your home. Okay, if you have these 2 mortgages, one mortgage company isn't going to want to go through the loan modification process until the other one becomes reinstated. And with the timeline that this occurs when you're going through mediation, you just simply don't have the time and you're really struggling to make sure you keep up with all those time constraints. That's an option that will stop the foreclosure process. Do we have any questions up until this point? Okay. Now, loan modification. Now, a borrower can modify directly with a servicer or contact a HUD-approved agency. Now, HUD-approved agencies aren't going to charge for the services, and I advise that you try to find one of these HUD-approved agencies because they are very well versed in what they need to do in providing documentation during the mediation process and the loan modification process. Now, other options is requesting a repayment plan for all the amounts that you currently owe. Typically when you go through a foreclosure process, it's not just going to be one payment that you missed. It's going to be multiple payments, sometimes even up to 6 months where you owe these amounts. Sometimes a lender will allow you to enter into what is called a repayment plan where you make certain amounts of payments. It depends on what they come up to the figure, but you can make it up to a certain period of time, say 4 to 5 months, where you pay that amount off and then you become current with your mortgage. Okay, so going back to the foreclosure process, again, I'm just only addressing the non-judicial aspect of it. The first act is a notice of default. After that, you're going to receive what's called a danger notice. The danger notice is basically telling you that you have 60 days before the sale of your property. So you're in danger of losing your house, hence the term danger notice. Now, when you receive the notice of default, you're going to receive also an election to enter into the foreclosure mediation process. A note on that, the foreclosure mediation process is going to end December 31st of this year, and there's going to be, for enrollment purposes, and there's going to be no other mediations after, I believe it's June 1st of 2017. After this period of time, we're uncertain exactly where it's going, but there's talk of that process being transferred to the greater Las Vegas area of realtors, and that they're going to be managing that aspect of mediation.
So mediation, this extra step will be taken away, and the consumer won't have this option anymore after June 1st. Is that what you're saying?
There's a potential, but I think that they're going to they're going to maintain the program under GLVAR, but we're not.
I think it's January 1st.
December 31st is no more enrollments,
Right.
and then after that, mediations will end June 1st of 2017. So if you're enrolled, you have to have that mediation within that time frame between January and June. In order to qualify currently under foreclosure mediation program, I'm going to abbreviate that as FMP for the time being because it's too long to constantly say. In order to enroll, you have to have an owner-occupied residence. So it cannot be it can't be a property that you're just investing in. You have to occupy that home. And they're gonna ask you for documentation to that effect. Now,
What if the property owner is deceased?
that becomes a little bit more complicated. What's your specific question in
I
regards
was
to that?
just wondering, like, because if the property owner,
Well, it depends. Are you on the title or are you on the mortgage?
no.
Okay. So if I'm just gonna give a brief
You gotta
example.
go through probate.
Yeah, the property's gonna have to go through probate, but if there's a situation where it resides, say that your name's on the title, but you're not in the mortgage, but you want to keep that home, you're gonna have to try and assume the mortgage, and so that's gonna be going through the loan modification process. That's typically the problem that I encounter. They want to, say spouses try to hold property as joint tenants, but that spouse isn't on the mortgage, okay?
Oh, okay.
So, notice of trustee sale. When a foreclosing trustee must wait at least 90 days after recording a notice of default. Now, obviously this time frame changes if you elect for mediation or in the next coming months after December, whether they determine to keep this program and transfer it to GLVAR. Just you're gonna have to do a little bit of research on that, or you can contact the different legal aid associations and they'll make sure to tell you what's going on currently with the state of affairs on that. So say you don't elect for mediation, and so your lender records the notice of default. So the next step is the foreclosing trustee must wait 90 days after recording the notice of default to issue the notice of trustee sale. After recording, it also must take 2 additional steps. They must post the notice in conspicuous place for 20 successive days, and the trustee must publish in a newspaper of general circulation for 3 consecutive weeks. Now, currently, as it stands with with FMP and how to elect for mediation, you'll receive when they basically post your notice of default and when they record it as well, you're going to receive a notice to also elect for mediation. If you receive the notice of default within that time period and you're able to elect for mediation, I highly advise you to elect for mediation. Now, the time frame for mediation must occur no later than 135 days after FMP receives the fee and documentation from the lender's trustee. So if you elect for mediation, you have to make sure that the mediation occurs within that time frame. And for the FMP, in terms of when mediations end, it's actually going to be June 30th, 2017. I think I said June 1st. So it's June 30th. Now the time frame in terms of when you elect for mediation. When you elect for mediation, your lender is going to ask for documentation. Okay. Now, you as the borrower, you have 15 days from the receipt of this list from your lender to obtain the info and provide the bank's representative as well as the mediator all your documentation. One important note is you really want to follow the time frames, because if you are not following the time frames and you're not providing the information that they're asking for, you're essentially not complying with mediation, and the mediator can issue a foreclosure certificate against you. Second request must come no later than 50 days after the lender received the first set of requests from you, the borrower. And there may be a third request for additional documentation that must be made within 5 days of the second request from the receipt of information. Now, mediation is a very informal process. You have a mediator, you usually have a lender's representative or a lender's attorney, and you the borrower, or if you have an attorney present with you, it'll be you and your attorney. If you're alone and you've elected for mediation, I always advise people that you really need to conduct yourself in a calm manner. I know emotions get in the way, and you're really concerned about losing your home. You may have concerns about what the lender did in the process, in terms of maybe they failed to accept the payment, or you feel that the foreclosure process that's been brought against you is unjust. But you need to maintain that calm demeanor and act in a professional manner. The bank, your lender or servicer, is acting more terms of, is this the correct business decision to modify your loan? so they have no emotion attached to your loan, and that's how they're going to respond in terms of making decisions based upon your loan. And I think that's important to understand because I think borrowers often forget that sometimes they need to make what is the best decision as opposed to making the emotional one of wanting to keep their home. There are various loan modification programs available. One of them is HAMP. I'm not going to get too much into loan modification programs. I'll explain a few of them, but for the purposes of time, I won't be getting into these because you'll hopefully be having someone who will be assisting you because there are HUD-approved locations that will be able to assist you with the exchange of documentation. Now, there's another program available for short sales. Short sale is going to occur when basically your home is underwater, when you owe more than what is actually on the note in terms of principal. So you owe more than your home is actually worth. In that particular circumstance, you're going to look at a short sale. One of the short sale programs that are available is called HAFA. Now, this goal under HAFA is to conduct a short sale. You're going to want to obviously associate with the realtor who's experienced in short sales because when you do this, you're going to want to make sure that you receive a deficiency waiver as well as some relocation money because that's the ultimate goal of that program, to receive some sort of relocation money to help you move and conduct the sale, and then you're able to move with a little bit of money in your pocket. Another form of modification is an in-house standard, which is going to be going through the loan servicer or the lender. Again, there are very different loan foreclosure alternatives. One of them is would be a deed in lieu of foreclosure. Essentially, you're giving your deed to your lender and for being able to walk away from the property. I only advise this if you can negotiate a deficiency waiver because you don't want to later on down the line, especially if your loan was originated after October 1st, 2009, to end up with a deficiency. And if you go through a foreclosure alternative, one of your goals is to come out the best way possible, and that would be negotiating deficiency waiver. It's not going to happen all the time, so again, you're going to have to detach your emotions from your decision. Yes.
I have an unrelated question. I'll wait till the end.
Okay,
It's
that's fine.
related, but then,
Okay. So going back to the mediation process, you're going through the mediation process, and so say you're unable to come to a resolution during mediation. So what's going to happen is there's going to be a mediator statement, and it's going to state what occurred within the mediation. If you come to an agreement, you're going to want that in the mediator statement, because after that, say if the lender violates the agreement, you can file what is called a petition for judicial review if they fail to comply with the agreement that you made in mediation. So you're going to want to make sure that that is as detailed as possible. If you make an agreement for deed in lieu of foreclosure, you're going to want to make sure it says deed in lieu of foreclosure in that little mediator's statement, as well as any other things such as deficiency waiver, anything of that nature. You want to make sure it's in the mediation statement because that's the only thing after mediation that you can use a petition judicial review to contest. So after mediation concludes, you'll be given what's called a vacate date. That does not mean you have to move out of your house during that time frame. It simply means that a foreclosure certificate will be issued in your case, and the lender has complied with all the rules and regs within the FMP program, and they are able to move forward with the foreclosure process. Now, say if you were unable to come to any agreement, you're going to want to get as much time as possible. I think 60 days is usually reasonable to ask. Between 30 and 60 days is usually what a lender's rep will provide to a borrower. It really depends on your circumstances and what you're trying to achieve. If you're trying to achieve a short sale and you need more time to find a potential purchaser, then they might provide you 90 days, but oftentimes it depends. But the goal is to make sure that you kind of have a time period set out a little bit further so that when the foreclosure certificate issues, you have some time to get your affairs in order, essentially. And especially if you're applying for a loan modification, and they don't have all the essential paperwork, you're going to want to make sure that there's sufficient time to which the lender can review your paperwork and make a decision. Another important note in terms of loan modifications in general, if you have a homeowners association, you're going to want to make sure that those fees are kept current. I've had multiple situations arise where a client had a loan modification agreement, they had a trial payment plan, they made their 3 payments, and come to find out, they have a lien due to their homeowners association, and they get denied for the loan modification. So now they're back to square one, and they've paid 3 payments of whatever amount the lender has determined. And so you're essentially out of, usually it'll run between $2,500 to $3,000 out of your money. Another foreclosure alternative is reinstatement. You can ask for an amount which is called payoff and request for, reinstatement, request for reinstatement. They're going to give you a dollar figure of how much you owe entirely on your mortgage as of that date, as well as how much it's going to cost to reinstate your mortgage. And that's going to vary with how many payments you've missed. Now, if you reinstate your mortgage, it's going to be typically a lump sum payment. This might be an option, say, if you have some assets that you can dispose of, such as a vehicle. You have 2 cars, you can sell a car and try and get that money and try and reinstate your mortgage. That's also an option. And oftentimes it comes down to that. You're reinstating your mortgage because there's no other alternative, and you thought you could get a loan modification. And as it turns out, you may not have enough income, or other factors are at play. Following mediation, once a certificate is issued, which is called a vacate date, it's going to basically allow the lender to move forward with the foreclosure process. After that period of time, you're going to receive a sale date from your lender or servicer indicating on what date and time your home is going to be sold. And again, that's one of those things you have to remain very aware of your incoming mail, and make sure that you're reviewing all these documents, because you don't want to miss something like that.
All right, so let's talk a little bit about the trail end of the foreclosure process. Chris was right, you really should be actively involved from start to finish, but basically at the end of the process you get the notice of sale. There's 21 days that have to elapse before the sale, and once the property is sold, sometimes it's at an auction in a law firm, at a real estate agent's office, the title to the property is transferred. So at that point, if you own the home, you become a tenant. And if you're a tenant in a home and it's been foreclosed, you're still a tenant, but you have a new landlord. So these situations arise. There are issues that you can take advantage of if you are the homeowner, if you are a tenant, and there are certain things you can do to protect yourself. So I'm going to try to go over some of those. Moving around is not good, right?
You're okay.
Oh, okay.
There's enough space.
Yeah, wide angle. All right, so first of all, if you're the homeowner, one thing that some homeowners consider is filing for bankruptcy. Filing for bankruptcy is really not an answer for most homeowners, because what they need to do in the Chapter 13, for instance, they need to pay off the arrearage during the 3 to 5 year period. So if you don't have income, if you don't have the possibility of getting a lump sum, then filing for bankruptcy protection is not really going to help you. The easier approach is just to go through mediation. As Chris talked about, the notice of sale, the notice of default gives you all the information that you need to pursue the mediation process, the foreclosure mediation process. Of course, it's ending in December, but we're talking for the next month and a half, you have that ability, and that's a much better, easier opportunity than going through a bankruptcy. A bankruptcy, just if you look at the cost, foreclosure mediation is $200, Chapter 13 is $315, so you're going to save yourself $100. So, all right, the notice of sale has been issued, the property's been sold. What happens first, if you are the owner of the home, the new owner can serve you an eviction notice. You are transformed from a homeowner into a tenant, and the new owner can give you a 3-day notice to vacate. So what you're looking at prior to the property being sold is a long, involved process that takes months, maybe 6 months to fully go through. Once you change ownership, the eviction process is quick. So you get a 3-day notice if you're the owner of the home. What follows is a summons and complaint for unlawful detainer. And what usually happens is there's an order shortening time. So you will get these papers, and within maybe 2 weeks, you'll have a hearing in justice court. And at that hearing, it's basically about the eviction, whether the judge is going to allow you to stay or whether you'll have to leave. And typically in these situations, if the new owner has followed the proper procedure, there really aren't defenses that you can bring up in justice court in the eviction. So it's 3 days plus another 2 weeks before the eviction hearing. It's called a temporary writ of restitution hearing. After that, it's over and you have to move out. So for homeowners, again, the notice of default, the notice of sale, that could take the minimum 3 months and 3 weeks. Once the property transfers, it's 3 days and 2 weeks. So it's much, much shorter if you are the owner of a home. If you have plans to file a lawsuit against your lender, let's say they didn't follow the proper foreclosure procedure, or there was something illegal that they did, you should talk to an attorney before the property is sold. I think there's a statute that allows you to sue if there is if the lender hasn't substantially complied with the trust deed foreclosure provisions, and I think you have 60 days. So you have 60 days to do that. The new owner, however, can evict you before those 60 days are over. So if you're thinking about suing your lender, you want to do that sooner rather than later. So if you are renting from the owner of a residential property and the owner has been foreclosed, as the tenant of that property, you're entitled to a little bit more time and you have greater rights than the owner of a home. And for this situation, I'm talking about a rental home, 4 units or less. This is usually a single-family home. Sometimes it's a fourplex. But if the owner of a fourplex has been foreclosed, the tenants of that home get a 60-day notice. So the 3-day notice for the owner of a home changes into a 60-day notice if you're the tenant of a home that's been foreclosed. And this is a home, it's 4 units or less, that's the distinction. The assumption here is it's a small landlord. Under these circumstances, the legislature saw fit to give them a 60-day, to allow them 60 days before the landlord could pursue the eviction. The other substantive right you have as a tenant in these situations is your former lease carries forward. So for 60 days, for that 60-day period, it's almost as if you had the same landlord because the same lease applies to the new owner. So if rent was $1,000, rent is going to continue to be $1,000. The lease carries forward. When we're talking about the rights as a tenant, there are some situations where, let's say, you're related to the owner. You might be the brother or sister, child of the owner. In those situations, all that matters here, you're a tenant if your name isn't on the mortgage. So some new owners will come in and say, you're related to, you're not a tenant, you're related to the owner, and that's not the standard. The standard is your name on the mortgage? If it's not on the mortgage, you're a tenant. After the 60 days expire, you have 2 months, a lease is enforced for that 60 days. After those 60 days expire, the new owner can then serve you that summons and complaint for unlawful detainer, and the hearing is usually within 2 weeks of getting the paperwork. And if you're a tenant, you have also instructions. You can file an answer, usually within 10 days. The thing you need to know is you don't really need to file an answer. You don't need to do anything except show up for the hearing. Usually you don't have a defense. You do have a defense if there's some deficiency in the process. Let's say you don't get a 60-day notice, but you get a 3-day notice. So if you're a tenant, you do have a defense to the eviction. You should have gotten a 60-day notice. You can bring that up at your hearing. After the hearing, the judge, or at the hearing, the judge decides whether you should be evicted or not. And then the judge will usually order your eviction. You don't, in these situations, you don't have a substantive defense when the new owner follows the proper procedure. All right, so let's say it's more than 4 units. Let's say it's an apartment complex that's been foreclosed. If it's more than 4 units, the procedure for an owner applies. It's a 3-day notice. So it's the same thing as an owner of a home. If you live in a large complex that's been foreclosed, you get a 3-day notice, and that's followed by a summons and complaint. The thing you need to realize, though, if a large complex has been bought and new owners take over, they're going to want to keep people there. They're not going to want to evict them. So typically, you won't see mass evictions at an apartment complex because they're interested in collecting the rent and they're interested in keeping occupancy high. All right, so in July of last year, the legislature created a definition of a tenant called a squatter. And with this change in Nevada law, they, I think, created a problem instead of solved a problem. But that's just my opinion. We'll talk a little bit about squatting. So when you're dealing with landlord-tenant situations, as a landlord, I think there's this idea that you should provide the least amount of notice possible and see if it works. And when you go over to Las Vegas Justice Court or Henderson or North Las Vegas, sometimes it does work. So you can have an owner of a mobile home and call him a owner of real property, of a home, call them a squatter and use this new provision of Nevada law. So this new provision of Nevada law, the squatting provision, requires only a 4-day notice. Now you're saying 4 days, that's more than 3 days. Yeah, it is more than 3 days, but there's no summons and complaint that follows. So if you don't respond to that 4-day notice, you get evicted. And the other thing that squatting allows a landlord, or allows the court to do, is look at what you file with the court. If the court thinks it's not sufficient, the court can order your eviction without a hearing. So as a landlord, that's very convenient. You issue the 4-day squatting notice. The tenant doesn't respond, the owner doesn't respond, whatever. You go in and get your eviction order, and the case is over.
I thought this was for homeless people squatting on abandoned property.
Right, that was the intention. And it's been our experience that in more than those situations, people will receive this 4-day squatting notice. It's actually called housebreaking. That's the official sort of definition. Housebreaking is whenever you enter property without permission and stay there. So you'll have a situation where, let's say you're moving to town and you rent an apartment off of Craigslist or some service. We see this a lot. The person that rents to you isn't the owner. They're just some scam artist. You sign a lease, you move in, the new owner comes around and says, "What are you doing here?" They give you a squatting notice. I mean, that is a typical, that fits the legal definition of squatting. Unfortunately, you're an innocent tenant who really isn't squatting. So you're caught in this sort of, this net, this squatting net.
Do they get their money damages back?
Mm-mm. So you'll pay a deposit, you'll pay first months, maybe first and second months. You pay a couple $1,000s. The person who takes that money just goes and rents out another vacant dwelling. So you never get that money. You get a 4-day, never get that money back. You get a 4-day notice and you have to leave in 4 days. And again, this is usually people who don't know the area, just moved to town, don't have contacts, things like that, so they're...
And victim assistance, does it help them?
You mean like the police? Yeah.
Yeah, like they can't go through victims assistance and get their money back?
I don't know, but I do know that the police were helpful in passing this squatting provision of Nevada law, so I would think classifying the person that's living in the house as a victim may be difficult for victims' assistance. Because if you're called a squatter, then potentially you're not the victim, but you're the criminal.
I see what you're saying.
So
But you don't know you're a squatter. You gave them all your.
you're not, well, okay, legally you are a squatter, but under traditional law, like before this change in Nevada law, in 2014 for instance, if there was somebody who moved in under an invalid lease, they were a tenant at will. So you're a tenant, you're not a squatter. And tenant is legal, squatter is quasi-legal or illegal. And that's what this provision of Nevada law does, it changes everything. A tenant's at will notice was a 5-day notice, so it was 1 day longer you'd have to wait. And I don't know why they changed the law, but they did. And if you're calling somebody who moves in there a victim, that may be difficult for some people to accept.
Yeah, because I gave you all my money. And I
Right.
made it.
It's very unfair, yes. And that's the thing, it's like, there's a simple and easy way to figure out if you're renting from the owner, and it's the assessor, the Clark County assessor. There's a website, you put in your address, and you see who the owner is. And if it says Bank of New York, Mellon, and you know Joe Smith is trying to rent it to you, it's like, what connection do you have to Bank of New York? And if they say none, then they're not the owner. And that's, I mean, most people don't know about that, and they get ripped off. Okay, so there's a 4-day notice if you're defined as a squatter. You're right, a squatter is generally the person who breaks in. When there's an eviction and the constable evicts, there's some red tape, there's some tape, maybe it's not red, but there's an eviction notice on the door and there's a cover on the door handle. And it says, it's illegal to break this. So what the squatters do is they break it and they move in and they set up shop. And so in those situations, yeah, technically it's illegal, it's trespassing, and now under this new housebreaking law, they can be taken to jail. And if they're taken to jail as the owner of the home, you can just retake the premises. You have to give this notice, property's being retaken, here's the name and address of the owner, but basically you change the locks and you take possession. 9 times out of 10 though, they're not taken to jail. And so as the owner, if this is a situation that you're facing, then you just give the 4-day housebreaking or squatting notice. All right, so if you are the recipient of this squatting notice and you're not a squatter, let's say you have a lease with the former owner and the owner was foreclosed. I had one situation where there was talk at the foreclosure sale that there were squatters in the house, so they paid less money to purchase the house at the foreclosure sale. And so they hired this eviction service, the eviction service served the squatting notice, and it was totally inappropriate because my guy had a lease, he had utility bills, he had the whole 9 yards of proving that he was a tenant. So the squatting notice was wrong, we won in court, but we had to go through, you know, this whole process because of this squatting provision of Nevada law, which was a little bit unfair. Anyway,
So
all right.
what happened, you were buying something and then some squatters came?
No, there was a foreclosure sale. So Chris talked about the notice of default, the notice of sale. The notice of sale is an actual auction that takes place. So they'll say 1234 Main Street going up for auction. What do I hear? You know, it's an auction.
Yeah.
So it's sold to an anonymous, to a third party. Let's say I'm an investor, I got a lot of money, so I buy the property, but there's talk like, hey, I wouldn't buy that property because there's squatters. And I guess that's what happened when this sale took place. So the new owner, you know, it could be an agent for the new owner because the price was lower. When there's squatters in your property, you're not going to pay as much. So there's incentive to say there's squatters. I call them bottom feeders. But this investor purchased the property and thought there were squatters there, so they gave a 4-day notice. And they didn't bother to knock on the door and say, do you have a lease with the former owner? Do you have any utility bills? You know, they didn't do any research, they just gave the 4-day notice.
Well, okay.
So, okay. Anyway, so if you do get this 4-day notice and you're not a squatter, your job is within those 4 days to file an affidavit with the Justice Court. So you file that, that's going to temporarily stop the eviction. The judge will look at the things that you've said in your affidavit, and if the judge feels that there's a defense, the judge will hold a hearing. So at the hearing, you go in, you're the new owner, the squatter or tenant is on the other side, and you basically, your argument, your issue is whether this person is a squatter or not. If you're not a squatter, the eviction's denied. So that's the sort of beauty of the squatting notice. If you win the hearing, they have to start over. So they have to start over, and they have to start over with a 60-day notice. So there is a silver lining to this dark cloud, and that is if you win the squatter's hearing, the landlord, the new owner, has to start over. All right, all this, what we're talking about is legal issues, when things go bad and they go to court. It's also good to keep in mind that if an owner is in foreclosure and they want to leave, if a tenant is in the property after the foreclosure, there's this informal sort of cash for keys process, whereas the new owner of the home, if you want to get a quick and easy resolution, you pay the person $1,000, $2,000, they turn over the keys, and there's no eviction, there's no squatting, there's nothing except an amicable sort of parting of ways. It's beneficial to the new owner to get that person out of there quickly and easily, and it's beneficial to the tenant to have some money to hire a van or rent a moving company. So oftentimes, if you are in this situation, it's very easy to just contact the new owner, see if there's a cash for keys offer, and sometimes you can get some money and easily move on without having to go through these legal issues.